everyone. This is Tom Fox, and I'd like to welcome you to episode 144 of the Fcpa Compliance and Ethics Report. Today I begin a two-part episode where I take a look at the Securities and Exchange Enforcement of the Foreign Corrupt Practices Act. This is a two-part episode, and this is part one. In this episode, I'm going to take a look at some of the jurisdictional issues unique to the SEC and some of the remedies they employ. The episode comes in at just under 20 minutes. I hope you enjoy it. If you have any questions, please contact me. Thank you for listening. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the Fcpa Compliance and Ethics Report. Today, I thought I would take a look at some of the issues specific to the Securities and Exchange Commission, or the SEC's enforcement of the Foreign Corrupt Practices Act. I think many or most compliance practitioners are certainly aware that the Department of Justice enforces the criminal side provisions of the Fcpa, but the SEC has a specific role in Fcpa enforcement as well, and that is on the civil side of things. So there are some unique jurisdictional issues, that are unique to the Fcpa, and there are some specific provisions that the Securities and Exchange Commission enforces as opposed to the Department of Justice. There's also some differences in damages or remedies and enforcement actions. So I want to really go into all of those a little bit here. Many people really don't think through the SEC's enforcement of the Fcpa, but it has a very significant role to play, and equally importantly, it has some damage remedies that are considerably different than those enforced by the Department of Justice. So we're going to explore those in a little bit of detail here in this episode. So first of all, who is covered under the SEC enforcement of the Fcpa? Well, it covers issuers, and those are defined as a company that has a class of securities registered pursuant to Section 12 of the Securities and Exchange Act, or is required to file an annual report or other report pursuant to Section 15 of the Securities and Exchange Act. The SEC also enforces the Fcpa against companies whose securities trade on the national exchange in the United States, including foreign issuers with exchange-traded American depository receipts and or trade on over-the-counter markets. So the SEC does not enforce against private companies, but they, of course, are subject to the criminal provisions of the Fcpa. The SEC also has some specific enforcement obligations, and these are under what are generally called the accounting provisions. And although the accounting provisions were originally enacted as part of the Fcpa in its original implementation in 1977, they do not apply to bribery-related violations. Rather, the accounting provisions ensure that all public companies account for all of their assets and liabilities accurately and in reasonable detail. That's going to turn into some significant enforcement mechanisms later, which we will go into. The Fcpa has, or rather the accounting provisions have two parts. First is the books and records, and second are the internal control provisions. So we're going to go into those in a little bit of detail. The books and records provision, of course, requires that the books and records accurately reflect the transactions and dispositions of the assets of the issuer in reasonable detail. And the internal controls provisions require that certain internal controls be present to provide reasonable assurances of the following four criteria: that transactions are executed in accordance with management's general or specific authorization, that transactions are recorded as necessary to permit preparation of financial statements in conformity with generally accepted accounting principles or other criteria applicable to such statements, and to maintain the accountability for the assets. Number three, that the access to assets is only permitted in accordance with management's general or specific authorizations. And 4, the recorded accountability for assets is compared with the existing assets at reasonable intervals, and appropriate action is taken with respect to any differences. So these reasonable assurances are defined as such level of detail and degree of assurances as would satisfy a reasonably prudent, a prudent official in the conduct of their own affairs. So neither the FCPA nor the FCPA guidance, which of course was jointly issued by the Securities and Exchange Commission and the Department of Justice in 2012, specifies a particular set of controls that companies are required to implement. However, I believe that with the implementation of the COSO 2013 framework, that will become the standard. The FCPA guidance does note that the internal controls provisions gives company the flexibility to develop and maintain a system of controls that is appropriate to their particular needs and circumstances. And an effective compliance program is a critical component of an issuer's internal controls. So you see how all this ties together into the FCPA. But the SEC's enforcement is really broader than simply the text of the Foreign Corrupt Practices Act itself. So in addition to the accounting provisions, there are other laws or regulations that the SEC enforces which tie into the Foreign Corrupt Practices Act. There are several provisions under Sarbanes-Oxley that have FCPA implications. These include Sox Provision Section 302, which require that principal officers of companies take a responsibility for and certify the integrity of company financial reports on a quarterly basis. Under SOX 404, companies must present annually their conclusion regarding the effectiveness of a company's internal controls over accounting. And finally, under SOX 802, it prohibits altering, destroying, mutilating, concealing, or falsifying records or documents or tangible objects with the intent to obstruct or influence a federal investigation, such as one which would occur under the FCPA. Now, when it comes to resolution tools, both the SEC and the DOJ use deferred prosecution and non-prosecution agreements, but the SEC, because it handles things on the civil side, has a couple of other tools. First is the cease and desist order, which typically or traditionally the SEC would get by going into district court. So the SEC would obtain a court order compelling a defendant to obey the law in the future. The violation of such order could result in civil or criminal contempt proceedings going forward. In most cases, defendants do not contest these orders, and there are no admissions made by the defendant regarding the conduct which may have violated the FCPA. There certainly has been criticism of no admission settlements in a wide variety of areas, and in a 2013 speech, SEC Chairperson Mary Jo White announced that the policy, there would be an expansion of the policy which would require the certain admissions under certain circumstances going forward. SEC Enforcement Chief Andrew Cerenzny has said that the SEC may require admitted violations in the case of egregious misconduct, such as cases involving obstruction of the SEC investigations or harms to a large number of investors. Now, the SEC also has the ability to take these cease and desist orders out of the district court and put them through the SEC administrative process. This was granted. This ability was granted under the Dodd-Frank Act, so there's yet another law which interplays with the SEC enforcement of the FCPA. There has been criticism of this new development where the SEC will take FCPA enforcement actions through its administrative process, but there's been no court ruling or other indication that this would be stopped or any other formal position taken by any regulator. Now, there has been, as I said, criticism by this, but as Mark Bone explained in an article in the FCPA blog entitled Our Administrative Proceedings, the New Civil Complaints, the Dodd-Frank amendments allowed this, and so there's really probably no procedural basis to fight this order. But it's important to note that because certain district court judges, federal district court judges, have refused to accept cease and desist orders, this may be a way for the Securities and Exchange Commission to avoid this going forward. Of course, as you would expect, the Fcpa professor has been unremitting in his criticism of this process, citing a lack of transparency. Among other criticisms, Mike Volkov has even weighed in, saying the SEC's new use of administrative proceedings for Fcpa cases demonstrates its unwillingness to face judicial scrutiny, and he believes undermines the effectiveness of its enforcement program. He ended by saying the SEC liked to play on its home turf and for some reason feels that going to court is not as important. Whatever your feeling about this is, I think it's certainly here to stay. Other criticisms have been more sharp. Terry Weiss, a litigator at Greenberg Traurig, was quoted in a Wall Street Journal article for the following: "I have no problem with the fairness of a case, fairness when a case is brought in federal district court and when it is overseen by a federal district judge who is appointed by the President of the United States and approved by the Senate. I have a significant problem when you have administrative law judges who are picked by the SEC." His fight there would obviously turn on Article 1 or Article 3 judges, but I think he misses the boat because of the authority granted under Dodd-Frank. So it looks like now the SEC will use its own administrative process to go forward, and it's something that we will probably see more of as enforcement actions move forward. So what are some of the differences in remedies? Well, the damages that are available as monetary fines are specified as the gross amount of the pecuniary gain to a defendant as a result of the violations or a specific dollar limitation. The specific dollar limitations are based on the egregiousness of the conduct, and it can range from $7,500 to $150,000 for an individual, to $75,000 to $725,000 for a company. Now, of course, that is per violation. So these can add up pretty quickly. The SEC has significantly multiplied these amounts, most egregiously or most publicly in a default judgment context against foreseeman executives. I would note that once again, that this was a default judgment, so there was no one on the other side contesting. But in that case, the SEC posited that 4 alleged bribes would be triple counted as 3 separate securities laws violations, once as a bribe, once as a books and records, and yet again as an internal control, thus multiplying 4 violations to create 12. So these could add up pretty quickly. It's not clear what a court's ruling on this might, or view on this might be. Nevertheless, it is something that is important for you to consider going forward, and the SEC may be able to stack these numbers and really ramp up the fines and penalties pretty quickly, particularly if you think of a bribery violation coupled with an accounting records, which would be 2 books and records and internal controls every time you have a violation. So it adds up pretty quickly. But the other area that the SEC has begun to use more aggressively and is unique to their remedy status or remedy structure is profit disgorgement. So the SEC can obtain equitable relief of disgorgement of ill-gotten gains and prejudgment interest, and can also obtain civil monies pursuant to the Securities and Exchange Act. The SEC can also seek ancillary relief, such as an accounting, so that the SEC can seek, and a district court may grant, other equitable relief that may be necessary and appropriate for the benefit of investors, such as enhanced remedial measures or the retention of an independent compliance consultant or monitor. Once again, turning to my good friend and colleague Mark Bone, who in a blog post entitled "What Exactly is Profit Disgorgement?" opined that it, or rather stated, it is an equitable remedy authorized by the Securities Exchange Act of 1934, used to deprive wrongdoers of their ill-gotten gains and deter violations of federal securities law. This allows the SEC to bring this as part of an administrative proceeding or a cease and desist order. These damages are calculated in the following manner. The SEC is required to distinguish between legally and illegally obtained profits. The first step in such calculation is to identify the causal link between the unlawful activity and the profit to be disgorged. Once the causal link is established, the SEC may assert its right to disgorge illicit profits that stem from the wrongdoing. Because calculations like these are often prove difficult, courts tend to give the SEC considerable discretion in determining what constitutes ill-gotten gain. If you read the Fcpa quite closely, you will not find any language regarding profit disgorgement as a remedy. However, profit disgorgement was made available to the SEC as a remedy in a completely different law that once again shows the interplay of various laws on Fcpa enforcement. And this completely different law is called the Penny Stock Reform Act of 1990. And under the Penny Stock Reform Act of 1990, there were 4 areas that the SEC was given authority to remedy. 1, to impose tiered civil money penalties pursuant to administrative findings of the Act, to enter an order requiring accounting and disgorgement, to issue cease and desist orders, and issue temporary restraining orders. Now, I would note for you that these remedies were not simply limited to violations of the Penny Stock Reform Act, but given as general remedies to the Securities and Exchange Commission. So, very interesting to see how this interplay or broadening of jurisdiction to the Securities and Exchange Commission came to be used in a different way at a later time. Finally, many compliance practitioners really don't focus on the Sarbanes-Oxley component of all this. And the most recent change to SEC enforcement came about because of Sarbanes-Oxley. So while Sox did obviously not amend the Fcpa itself, it did amend both civil and criminal securities laws relating to compliance internal controls. So since enactment of Sox, the SEC has possessed the authority to designate how a particular penalty that it assesses will be classified. So once again, interesting to see how Sox interplayed with all of this. So we have profit disgorgement is now a remedy available to the SEC, although it came to the SEC through the Penny Stock Reform Act. And what we're going to do in our next episode is take a look at how all of this plays together and how the SEC may be using this information going forward. I'm also going to take a look at some recent public commentary by the SEC, because I think it's important to note that the SEC communicates with the compliance community in a variety of ways, one of which is through public speeches. These speeches are to conferences, sometimes in testimony to Congress, but the SEC clearly communicates to us what they view as important, where their enforcement priorities lie, and how they're going to move forward. It's not a matter of you having to read the tea leaves. The information is out there for you. And in the case of the SEC, whenever they give a speech, the text, printed text of the remarks are available on the SEC website. So it's there for all to see. Commentators will post blogs or even podcasts about some of their remarks. So we're going to take a look at some of the most recent communications from the SEC regarding what their priorities are and their discussion of some of the bribery schemes that they have seen. This is Tom Fox. I hope you've enjoyed this, what turned into be part 1 of my discussion about the SEC enforcement of the Fcpa. If you have any questions on this, you can contact me at tfox@tfoxlaw.com. Thank you very much.